Good morning, and welcome all to the last in our series of 4 construction winter webinars. I think it's our equivalent of the last instalment of the Harry Potter franchise. I hope that you don't find it quite as dark as the Deathly Hallows, but I do hope that you think it's magic, to use a popular Glasgow expression. I'm Gavin Payton, a partner in the Construction and Projects division, and I'll be chairing the session today. Our presenters are my colleagues Kathleen McAnee and Karen Manning, both directors in the division, and both at the leading edge of the drafting and negotiation of construction documentation. That experience makes them ideally placed in terms of taking this talk through negotiation on hot topics in the construction sector and the agenda today. In the session, Kathleen and Karen will be discussing some key issues that we see clients facing in negotiations of construction documentation at the moment. The first of those is material shortages and the consequences, some pandemic-related issues, PI insurance, and limitations on liability. Before I hand over to Kathleen and Karen, just a few housekeeping points. We automatically muted you when you joined the call to limit background noise, and if you could keep your selves on mute, that would be appreciated. But, and this is an important but, we are very keen for you to ask questions, and you can do so by using the Zoom chat function. And if you could direct those questions to me on that, that would be fantastic. We'll do our best to answer your questions, but if you prefer to contact us after the session, contact details will be displayed at the end. We're recording today's session, and the recording will be made available shortly, along with the recordings of the other sessions that have been in this seminar series. That'll all be early next week. We're aiming to wrap things up about 12:45, and that should allow some time for any final questions at the end. So I'll now hand over to Kathleen. Thanks, Kathleen.
Thanks, Gavin. Good afternoon, everyone. So material shortages and the consequences. Back in May, I wrote a blog on the construction material shortages and the perfect storm of an increase in home improvements due to lockdown, a global shortage of raw materials, increased labour rates and shortage of labour, the impact of Brexit on imports, a shortage of haulage containers, and the impact of COVID. They were all blamed. Also throw in the curveballs of an unusually warm climate in Scandinavia, impacting the supply of timber, the blockage of the Suez Canal, and floods in Texas impacting plastics production. It was the perfect storm. It is now November, and that perfect storm continues. In the last month, Construction News reported that 8 in 10 SME builders have had to delay work as they struggle to access materials they need to complete jobs. In a survey of more than 300 business owners, the Federation of Master Builders reported that 82% of builders said they delayed work in the third quarter of 2021 due to material shortages. A further 8% said they were forced to cancel jobs altogether. 93% of respondents said they were expected material price rises to continue into the fourth quarter. 6 in 10 of surveyed respondents said they had to stop work due to the skills shortage, while an additional 12% cancelled jobs due to skills issues. Vacancies across the construction industry hit a record high in September, with 43,000 posts unfilled across the UK. Steel supplies took another dip in October after European trade bodies warned that Chinese imports of magnesium were drying up. Some good news though, that timber supplies, though, should now meet the UK's high demand, but coupled with the HGV driver crisis that's expected to continue, this will impact the distribution of timber. So not good news at all. How are we seeing this addressed contractually? So the procuring of materials for a project is usually a contractor risk. We are seeing contractors who've tendered for a project, but the contract is not yet signed, advising that the work simply cannot be done for the price tendered, and within the due to the increase in materials costs. The proposal being, well, we'll build you less, but for the same price. One contractor we spoke to had quoted a 10% uplift from suppliers and steel increasing by nearly 40%. We are seeing upfront discussions with contractors looking to ring fence the risk associated with procuring specific materials where they know that the price is fluctuating and deliveries are delayed, perhaps tying them into pre-orders. We're seeing tighter timescales for acceptance of tenders so that advance orders can be placed, and actually fairly bolshy discussions about price increases if this does happen. To the extent it's been, please accept our tender by this price, otherwise our price will not be held. There'll be no goodwill at all. We're looking at contract reviews to identify ways to claw back the rising costs of materials, which have gone way beyond the inbuilt tolerance for price fluctuation factored into their fixed price contract. So how the material substitution provisions work, whether there's a material price escalation clause, or could we somehow construct an argument around force majeure? We're also seeing the inclusion of fluctuation provisions, which for the contract drafters of a certain age in the audience will know that this is highly unusual. We're also seeing attempts to achieve extremely flexible completion dates, not always successfully, in house building projects. We're also seeing requests for advance payments to make orders and the use of off-site material certificates. I'll bring Karen in here. You've had some experience of this recently.
Thanks, Kathleen. Yeah, I have seen a lot more discussion about advance payments and off-site materials agreements to try essentially and short circuit issues with shortages and availability. I would say be very wary about paying in advance for off-site materials. If you're an employer, security for any such advance payment should be carefully considered. There are lots of options for security out there: advance payment bonds, off-site materials bonds, parent company guarantees, off-site materials agreements, vesting certificates. I could go on and on. Some are better than others. As always, the devil is in the detail, and often these agreements are bespoke, so approach them with caution. One of the things that is a key issue with off-site materials and not always appreciated is the differences between England and Scotland on the subject. There are quite different approaches that you should be aware of. In kind of brief summary, in English law, ownership of materials can be transferred once they have been set aside by the contractor and they've been paid for by the employer. Delivery is not a requirement. However, in a Scots law contract, if you have a building or engineering contract, ownership of the property can only pass when there's both intention to transfer ownership and delivery. So if an employer is going to agree to pay a contractor for materials before they're delivered to site in Scotland, the building contract can't be used to transfer ownership of those materials to the employer. There is an exception to that rule, and that is if your contract is categorised as a contract of sale, because that means it is subject to the Sale of Goods Act 1979, and that means that ownership of the property can pass by agreement being made rather than on delivery. So under Scots law, a separate contract is required if you're going to purchase materials from a contractor or subcontractor, and in that circumstance, materials will not form part of the building contract. It'll essentially be extracted and be governed by this separate contract of sale, which is usually known as an off-site materials agreement. So moving on from material shortages to our second hot topic, the pandemic. I mean, we couldn't really have a hot topic session, unfortunately, without mentioning COVID-19. And Kathleen has obviously touched on it specifically in relation to material shortages, but more generally, the impact of COVID is definitely still a concern and it's still a challenge. We're seeing contractual relief for COVID-19 related events being sought by contractors and developers in their negotiations with end employers, and that's almost daily in our experience. And interestingly as well, it's even being introduced by the end employers themselves. I've had quite a few instances of employer clients saying, let's deal with this now. We accept that the contractor should be entitled to relief in these sorts of circumstances. Let's include the parameters of that in the tender documentation. And so there's lots of COVID-related discussions in negotiations as we see it. We did have a purely COVID-19 related winter webinar session last year. Gavin and I did that, and the whole session covered COVID. And I know some of you attended that, so I'm not intending to rehash what was discussed there, but it is interesting to reflect on the content of that session and some of our predictions and compare kind of what we are seeing now. On reflection, there's definitely some common practices now in terms of approach, which is different to the position that we had a year ago. The relevant relief drafting tends to focus around extensions of time and not money. Contractors are generally resigned to the fact that no loss and expense will be payable in the event of a COVID-19 related delay. Clauses are generally concerned with a change from the status quo, and that position generally seems to be accepted by both employers and contractors. There's a bit of a concern, an accepted concern around mutations that might lead to future outbreaks that are not categorised as COVID-19. So you tend to see reference to mutations or otherwise of COVID-19, of the COVID-19 virus. And as well as the natural consequences and effects attributable to the outbreak of the virus, COVID events usually cover any changes in statutory regulations and relevant guidances as well. And of course, contractors, as Kath has mentioned, they are looking for the entitlement to include for the consequence of shortages in materials, also the consequences of shortages in labour, etc. I think one of the key challenges in pandemic-related negotiations at the moment is that we don't have an established market standard in the industry for COVID-19 relief. There has been some example drafting that has emerged by industry bodies, including the Construction Leadership Council, but the take-up on this hasn't really been much in our experience, and that means that the drafting and negotiation process on these sorts of clauses can be quite protracted. I would say that it's important to consider the detail of your bespoke provisions very, very carefully. We've seen quite a few instances of COVID-19 relief drafting appearing in contracts with limited consideration as to the full consequences of its inclusion. So parties should ensure they consider full terms of the contract and any impact that COVID-19 relief drafting may have or should have on the contract. A good example of that is the obvious one of providing for extensions of time in the case of any COVID-19 related delay, but not following that through, if it's appropriate to do so, to the rights of a party to terminate the contract. For the most part, there also appears to be an acceptance in the industry now that COVID-19 related events do not constitute force majeure, they do not constitute unforeseeable events, and they do need to be dealt with in their own right. And that's certainly something we would recommend. If you do want to, agree COVID-19 relief, you should draft for this specifically. And I think that's something, Kathleen, you'd agree with, isn't it?
Yeah, I would agree. Whilst COVID drafting isn't really a situation anyone really wants to deal with, again, we're definitely still having to draft COVID clauses. I think there does seem to be an awareness, which is good from a lawyer's perspective, that it's better to have specific drafting to deal with COVID rather than trying to rely on the force majeure or other standard form provisions. There seems to be a bit of unease with some clients that I spoke to. I think perhaps with its roots and direction from the Scottish Government during the various lockdowns, that it was merely advice that construction sites remained closed at certain points, and that the risk assessment as to whether to crack on actually with employers, contractors, and a discussion between them, that relying on, or maybe grasping at, is probably a better word, better phrase, the standard form provisions resulted in just a complete contractual muddle. And so therefore it's better to deal with COVID drafting head on. My experience is the same as yours, that it seems to be that people are actually pretty reasonable about it. They're acknowledging what reasonable periods of suspension could be, whether there should be consequences such as termination. And I've actually seen people be able to recover their reasonable costs as well, to demobilise to a certain extent and make sure that sites are secure.
Yeah.
I'd be interested if the audience actually agrees with that perception. Perhaps it's something we can pick up after this session.
Good plan. Okay, so moving on to our third hot topic, which is professional indemnity insurance. I'm sure most of you are aware that we're facing quite a difficult professional indemnity insurance market at the moment. We've got more restrictions on cover being imposed by insurance firms. We've got tougher conditions being imposed by insurance firms, and we're seeing real struggles by contractors and consultants to obtain the PI cover at the level and basis that is required. Sometimes that is being accepted on the employer side. Sometimes contractors and consultants are having to omit certain scopes of work or scopes of service to reflect the insurance conditions being imposed on them. And it's not just an issue for new projects. There are renewal issues too. It's common to have an obligation to notify if insurance is no longer available. And there actually is a professional indemnity insurance practice note that was published by REBA, which recommends that existing contracts are checked to identify specific notification requirements. So a really good practice note. Certainly would recommend it for a read. It provides additional advice about communicating with insurance brokers, record keeping, robust quality management, and the like, general kind of robust quality management systems and risk management too. We're starting to see new exclusions and limitations coming through, even when the insurance can actually be obtained. And I'm sure all of you are aware that most construction contracts will contain an obligation to maintain PI cover for a set level on a set basis for typically a period of usually 6 or 12 years from practical completion of the relevant works or the relevant services. And we are now seeing notifications coming through that the specified level's not available or the basis of cover is no longer achievable, particularly in the case of cover in respect of fire safety and cladding. What else are we seeing? Each and every cover is getting rarer and rarer. It appears to be very difficult to get now in the current market. Annual aggregate policies are being offered in the alternative, so more attention is having to be paid to the details of any aggregate cover. I would be wary of the finer details of aggregate policies, the nature of any reinstatements. If there are reinstatements, are those automatic? Are those round the clock? Are there specific conditions or terms attached to those reinstatements, and how and when they might apply? Contracts, in terms of contract drafting, the contracts themselves often include an obligation to maintain PI insurance only so far as the insurance is available at commercially reasonable rates and terms. So that is very helpful to have from a contractor or a consultant perspective, especially in the current market. From an employer perspective, employers need to interrogate the impact of that caveat really carefully. If they're faced with a proposal from a contractor or a consultant that the PI cover is no longer available at the required level or on the basis set out in the contract, they should ensure substantiation is provided from the relevant brokers, and that they fully kind of consider and understand any consequences that there may be on the development. Another issue I wanted to mention in relation to professional indemnity insurance is that of premium increases. Following Grenfell, I mean, insurers saw such a large increase in notifications of potential claims due to defective cladding, which ultimately caused insurance premiums to go up. And the other challenges that the insurance market faced, including the reduction of the availability of appropriate policies, also contributed to increased premiums. And we're involved in a lot of those conversations with clients about increased costs and how those might be dealt with. We're also seeing the higher premiums reason forming part of the commercially reasonable rates debate, which I mentioned earlier, and people are using that as a reason that a specified level or a basis of cover in existing contracts can no longer be maintained. I think it's a difficult one in terms of cost increases as to who bears the risk of that, and we're certainly seeing it being managed in different ways in the industry. Moving on to uninsured risk, which is probably the last aspect of professional indemnity insurance I wanted to mention. If latent defects arise on a project, we think it's going to now be more likely that employers could find themselves in a position where, despite what the contract even says, there's no insurance cover in place to cover those defects. That is obviously a significant issue, and it could greatly increase the risk profile associated with certain projects. It should be the responsibility of the insured to ensure that the cover they have is sufficient to meet the requirements of any insurance terms and to cover the risks associated with their scope. However, if that's not the case, or the insured fails in that regard, the employer is likely to be exposed to uninsured risk. And if the contractor or the consultant is not of sufficient covenant to recompense the employer for any losses, it will be the employer who bears the brunt of any uninsured loss. So there is a bit to do on the employer side to try and guard against that risk. They need to be putting in place suitable contractual protection in the first instance, but also risk management processes to guard against this. And that's not just before and during the project, but beyond as well, given the time frame that professional indemnity insurance should be in play for. And they should be insisting to see, relevant insurance policies or and evidence on a regular basis. So to conclude on the insurance front, PI insurance is definitely now, I think, at the forefront of risk analysis and management when negotiating a construction contract. We're seeing more involvement from brokers. We're seeing more resistance by contractors and consultants to risk and tougher negotiations. And this includes more discussion and requests for the likes of limitations on liability, which brings us nicely on to our next subject.
I wonder, Karen, if I can just interject there just with a question from the chat function, if that's okay.
Yeah, of course.
Yeah, it's in relation to, well, the question is, how are the increased costs in PI cover being managed in the industry?
Yeah.
You happy to take that now?
Absolutely, yeah. I'll just feedback. It's a good question. Quite differently in our experience is the short answer. Very different ways. In some cases, contractors and consultants are absorbing the cost themselves, the cost increase themselves. In other cases, I've seen a split of the costs agreed between contractor and contractor/consultant and employer. We also had probably about 9 months ago now, one instance where a client actually agreed to pay for the increased costs in full. Now, that was not without its complexities, because professional indemnity insurance is an annual policy which renews yearly, and the premium obviously was not going to stay the same on a yearly basis, and there was some uncertainty as to what the premium would be. And the policy also was not a project specific policy. It's a policy that was going to benefit that particular consultant in relation to any project that they were involved in, not just the client's project. So there was some quite bespoke principles that had to be agreed in relation to that payment and how that payment was made. But in essence, that in that one circumstance, the client did pay for the increased cost in full. So quite a varying range of approaches across the board, all very much dependent on the circumstances of the particular project and the bargaining position of the parties.
That's great. Thanks, Karen.
Okay, I think it's over to me now. And I'm going to look at some limitations of liabilities and trends that we are seeing. I think if we step back maybe 15 years ago, it was only the very bold contractors in large D&B contracts who would ask to limit their liability. Now it seems that in any contract review, a list of limitations is the norm, whether in a large project, a minor works contract, or a subcontractor collateral warranty. There's likely a good few reasons for this trend. The challenging PI market, which Karen's obviously just talked about, we are seeing parties trying to limit their exposure to risk by exclusions and limitations, and then trying to align that with their trying to align it with their tightened insurance cover. The current volatility of the construction market, which I touched upon at the start. The construction market generally becoming more litigious and increasing claims over the years, and generally folk being more knowledgeable about the ins and outs of their contracts. Specifically today, I'm going to discuss caps on liability, including subcaps. Secondly, the word exclusions, and specifically indirect and consequential losses. Thirdly, other knock-on considerations. And 4, a little on contract interpretation generally. So let's look at caps first. When considering risk, the 2 key questions you need to address are firstly, who takes the risk? And secondly, how do you manage that contractually? Aside from pricing the risk, contractually you manage it by seeking to cap your liability. A cap, properly drafted, can have the effect of limiting liability to a maximum amount. It can be an aggregate cap, a fixed amount expressed as a flat figure, for example, £10 million, or a percentage of the contract sum. Or it can be a flexible cap with a ramping down after key stages, for example, a higher cap before takeover or PC and a lower cap post-completion. It can be a cap for each and every claim or series of claims arising from the same event. Now you can see with that when I end up a dispute about whether different claims are connected or not. An aggregate cap can also include specific subcaps for specific events or heads of loss. It's important to appreciate that a cap on liability is a standalone clause. Without a cap, liability is unlimited, regardless of the level of insurance that may be maintained. Whilst insurance does cover liability under the contract, it's simply a protection against meeting the entirety of the claim from the company's pocket. It doesn't itself operate as a cap. As Karen touched on also, insurance will contain exclusions. Full cover may only be secured through optional endorsements. And of course, all insurance is subject to excess and various deductibles, which will bite out into any payout. Just because a party has insurance of £10 million doesn't mean that that should be their cap. That £10 million may well be disproportionately high based on the scope or value of the works. On a recent project, we had a large contractor carrying out a tiny little amount of works for them. It was a £70,000 contract. But when we asked them, they asked for a cap on liability, and when we asked them what level their PI was, they said, oh, well, it's about £20 million. We do stuff in the Middle East. So this was absolutely small fry for them. And obviously a cap of liability of £20 million on a 70 grand project would be completely ridiculous. An insured party, though, should also try and fix their liability cap at a lower level than their maximum insurance cover level. Insurers can look at how contract liability is managed by their insured and can adjust premium based on this behaviour. Further, if you're on the consultant side of things, we would advise not to begin from the assumption that the level of fee equates to the level of the cap. It's quite a crude mathematics to link the value of the contract in terms of fees to the level of the cap. Say an equivalent of 10 times the fee, which is commonly the starting point in like the ACE contracts or the RIAS standard forms. You can do £1 worth of work, but you can do £1 million worth of damage. The SBCC clause 219 provides a cap in relation to consequential losses arising from negligent design. This is often stated as the level of PII. It's worth remembering, however, that this is not an overall cap, and if you're a contractor seeking an overall cap and liability, a specific clause has to be included and it has to go beyond that envisaged by clause 219. Turning now to look at subcaps. Subcaps exist to limit liability for specific events or heads of loss. For those of you familiar with the NEC suite of contracts will know that option X18, so long as it's selected, is probably one of the main points in negotiation. It provides for an aggregate cap with provision for subcaps for indirect and consequential losses, loss or damage to the client's property, and latent defects, being defects not listed on the defect certificate. In the NEC, you can also select option X7 to apply delay damages. Any delay damages payable are excluded from the aggregate cap. If you want to cap delay damages, you would need to amend the NEC4 using a Z clause. In agreeing to this, it's important for an employer to undertake a technical analysis to test what delay period would be covered before the cap is reached. Is it consistent with the nature of the works? Have you built in a safety buffer? Uninsured losses may also be subject to a separate subcap, but we would suggest that referring to such terms as uninsured or uninsurable, as referred to by Karen, need to be reviewed carefully and verified with your insurance advisors. Finally, specific heads of loss can be subject to a subcap, such as those arising from loss of use, loss of profit, or other consequential losses arising from negligent design, like the SPCC 219. And I do wonder whether they are actually going to be more common nowadays. Moving on, let's look at the word exclusion. Now, it might seem strange to focus just on a particular word, but I think it does actually have it's got some interesting interpretations. And it's an area for potential confusing in the drafting of caps and liability. A cap sets the maximum limit for the remedy which is available to the innocent party in relation to a particular claim. Beyond that, the parties may agree that the liability is excluded entirely for certain matters. For example, as I mentioned, loss of profit, indirect or consequential losses, which I'll come on to later in more detail, and losses arising from fraud. It's not uncommon to see the list go even further and a whole list of exclusions, and the totally fair question from junior lawyers learning their trade of, well, what are they on the hook for? Parties may also agree that whilst the cap applies, there are certain liabilities which are excluded from that cap and are therefore uncapped. For example, a number of indemnities in the contract, some of which can't be limited in law. For example, liabilities for death and personal injury. We would urge caution when agreeing exclusions, and you have to be extremely clear whether you mean exclusion from any liability or exclusion from the cap which limits liability, as these are close to being completely polar opposites. I mentioned earlier that I've discussed the common exclusion or subcaps relating to indirect or consequential loss. I think that these merit further discussion due to some recent and fairly interesting case law. There are two main schools of thought as to how indirect and consequential loss is ascertained. Approach one is the modern approach, the natural meaning of the words, what a reasonable business person would think the parties meant by it. Approach two is the traditional approach derived from the well-known Hadley against Baxendale case of 1854, which is these words mean the losses that are not the natural results of the breach in the usual course of things, but arise from a special circumstance of the case. These losses are only recoverable as damages for breach of contract if the paying party was in a position to know of the special circumstances when it made the contract. Recent cases have considered how the words indirect and consequential losses are interpreted. Assumptions had been made by the courts as to how the words would be interpreted, but more recently and increasingly, the courts have taken a much more interpretive approach to the test and have followed approach one, the modern approach, what a reasonable business person would think the parties meant by it. From a drafting perspective, it's common for people to list matters which are considered to be consequential losses in an attempt to completely exclude them. But then this risks those losses getting caught by them being direct losses. For example, contrary to popular belief, an exclusion of indirect and consequential loss may not give much protection against financial losses because the financial losses may well be direct. Accordingly, from a drafting perspective, it's better to focus on a list rather than using the words indirect or consequential. Most people in the audience will be familiar with references to third-party agreements and contracts and provisions which require compliance by a contractor or a consultant with the third-party agreement, provided in advance in the execution of the contract, provision not to put the employer in breach of their obligations in the third-party agreement, and provision that any losses incurred as a consequence of the breach to be within the contemplation of the contractor or the consultant, and often an indemnity in respect of such losses. This type of drafting avoids any reference to indirect or consequential losses and is a good example of dealing with situations where there's the potential for losses to be incurred and how to manage liability for potential losses in a contract. We had a recent discussion with a contractor in relation to liabilities in an infrastructure project, and quite reasonably they were comfortable, well, when I say comfortable, that's maybe too strong a word, they were accepting of their potential liability to the developer in relation to the documents they had seen. But they were not comfortable accepting liability for variations to the documents or new agreements that the developer entered into in the future. This seems entirely reasonable, but it made for some interesting discussions as to what their potential liability could be. And whilst a financial cap wasn't agreed, having sight of the third-party agreements as part of the tender package meant that the contractor could make a judgment call on their potential liability if they agreed an indemnity. The overriding takeaway is that specific circumstances of the deal should be considered in the drafting, and discussions, often quite difficult discussions, need to be had, and the parties have to be aware of what they're agreeing, and to know that in the event of a dispute there may well be a debate as to what is and is not indirect or consequential. A couple of other points to mention in relation to the consequences of agreeing limitations of liability, and that's in relation to termination. If there's an aggregate cap which is fully consumed, you have no headroom for compensation on termination payments. So should there be a termination trigger when the contractor consumes maybe 70 or 80% of an aggregate cap, to preserve a portion of the aggregate cap for compensation and termination. Similarly, when you have a liquidated damages cap, when 100% of that cap is consumed, you will have no ability to claim further damages for culpable delay. So you might want a termination trigger at that point. We often see an option for the contractor also to increase the cap at that point to avoid termination, which is particularly useful if the works are actually nearing completion. Finally, I'm just going to say a few words on contract interpretation. It is worth remembering that the rules of contract interpretation apply to limitation clauses as they do all clauses. Businesses are free to allocate risk as they choose, and the courts generally agree to respect their intentions. It is accepted that some contract terms may be unreasonable or unfair, and yet they will still be held to be enforceable contract terms. The rules around interpretation are flexible enough to let a judge apply or discount the literal meaning of a clause, giving effect to the party's intention as perceived by the judge. Clear, considered, and precise drafting allows parties to have a greater degree of certainty that courts will not intervene in the event of a dispute. If the drafting of a contract suggests that both parties had dedicated time to arriving at an agreed bespoke solution which addresses the specific circumstances of arrangements, and if it's a professionally drafted contract, then the courts are less likely to intervene. So what conclusions can we draw in relation to limitations? I think requests for limitations of liability are now the market norm. With the challenges in the insurance market, will we see the NEC X18 approach being used in other forms of contract? I think we probably will. Contractors and consultants have to give due consideration to what limitations they are seeking and be prepared to have open discussions about their risk analysis behind the request for inclusions of limitations. Employers need to assess what, if any, would be fair to accept. You also have to make sure that both parties are on the same page when discussing exclusions. Parties need to consider if there's any knock-on consequences for agreeing caps, particularly for an employer. What do they want to happen if they use up the cap, particularly in relation to LADs? As with all contractual negotiations, communication is key, together with clear, considered and precise drafting to allow the parties to have a greater degree of certainty. And with that, I will hand back to Gavin.
Great, thanks, Kathleen. We'll now move into the Q&A session. I've got, please do add your questions to the chat function, and we can look at those. I do have one question here at the moment, Kathleen, which relates to the topic that you've just finished discussing. I'll read it out. It's, do you find that there is much appetite outside the NEC contract for agreeing subcaps, or do you think this is something we'll see more of?
It's a good question. I think we'll definitely see more of it. I think, as I touched on, I think insurers will have an expectation that the insured parties push for more limitations. And I think sometimes the agreeing of subcaps is a way to deal with particular liabilities head on. It seems fair that certain liabilities should have different caps. That doesn't seem an unfair proposition. It's also, I think, as the NEC becomes more widely used, we'll see it infiltrate into other forms of contract as well. So yeah. Yes, I do.
Okay, thanks, Kathleen. That's great. Just looking at the chat function, either it's not working or the questions are not flooding in. Anyone, any final questions you'd like to ask? Kathleen and Karen have done a fantastic job of keeping us on schedule, but we do have a couple of minutes for questions if anyone's got anything. Okay, well, if not, I'll wrap things up and say, well, thanks to Kathleen and Karen for fantastic presentations. You know, for me, some of the key takeaways for the session today are, I think, around market position in terms of negotiation. And what we're seeing is the market position shifting on quite a few issues, actually. More than ever, contractors and consultants are alive to risk. Them having seen, quite a number of their peers in the industry suffer the consequences of the pandemic and some of the other issues discussed today, and with some long-established contractors and consultants slipping into insolvency. And as a consequence, I think what we're seeing is contractors and consultants being more than ever alive to risk and seeing a shift in the allocation of risk in the market from contractors and consultants to their clients. Overall, that means negotiations are getting tougher at the moment, or have been tougher. I think the good news, though, is that we seem to have a reasonably lively construction market, and through time, I would expect the new world market position, if we can call it that, to become clearer and clearer as time goes on. And we're seeing that already. I think the market position on COVID, for example, is becoming fairly settled. And I think we'll see that also in some of these other issues that we've talked about today. So once again, thanks to Kathleen and Karen. Thanks to all of you for finding the time to join us today. Please contact myself, Kathleen or Karen, if there are any issues that you want to follow up on. As I said out at the outset, the recordings of all 4 sessions will be published shortly. I don't know, probably won't remember the flyer that was issued when this seminar series was announced. It contained a quote from Aldous Huxley's classic novel, Brave New World. And that quote was as follows: "Stability isn't nearly so spectacular as instability." So, having thought about that, I'll end by saying I hope you all have an unspectacular end to the year. Thanks for joining us today.